Welcome, I am the Loud Little Ducky. Today we are going over the Notice of Appeal and the amended to that appeal in the Owens v. Echard case. And it's a bunch of hogwash, but let's settle in and see what's going on. So first, I do want to cover this application for attorney's fees and costs. I don't think I have covered this document, but it was on August 19th, 2024. And it says, this matter having come before the court upon respondents' applications of attorney's fees and costs and upon consideration of respondents' affidavit of attorney's fees and costs, China Doll affidavit filed on July 8, 2024, and petitioner's response/objection filed on July 29, 2024, and good cause appearing. It is ordered entering judgment in favor of respondent and against petitioners as for attorney's fees and costs in the sum of $149,219.76. It is further ordered the petitioner shall satisfy the judgment within 180 days of entry of this order. If petitioner fails to do so, said judgment shall accrue interest at the legal rate until paid in full. Signed, the Honorable Judge Julie Matta. And if I have covered it, well, here it is again, just so we know. The courts have fully ruled in Clayton's favor on the things that she could rule. She could not touch the order against harassment, but everything else she was able to rule on. The sanctions, Laura has lost. So here we have in Maricopa County Superior Court, State of Arizona, filed by Gingras, the Notice of Appeal in Owens v. Echard. Says, pursuant to Arizona Rules of Civil Appellate Procedures 8A, petitioner Laura Owens, Laura or petitioner, gives notice of the appeals to the Arizona Court of Appeals from the final judgment entitled Order Re Application for Attorney's Fees and Costs, dated August 16, 2024, and filed in this matter on August 19, 2024, the fee judgment. Laura further seeks review of all prior non-appealable interlocutory decisions, orders, and rulings by Superior Court prior to the entry of final judgment. See Motley v. Simmons, a appellate court case in 2023. In explaining in a timely appeal from final judgment, the appellate court shall review my intermediate orders involving the merits of the action and necessary affecting judgment and all orders and ruling assigned as error. Citing Pepsi-Cola Metro Bottling Company versus Romley, an appellate case in 1978. Holding timely appeal from final judgment allows the appellate court to consider all prior non-appealable orders. For the appellate court's benefit, Laura notes an obvious issue. The fee agreement does not contain the final certification required by family law Rule 78C, and thus the judgment would ordinarily not be appealable standalone. Nevertheless, in light of the unfortunately complicated procedural history of this matter, it is clear the fee judgment is final and properly appealable as a matter of right. You know what? There is a lot of twists and turns in this story, and they all come from Owens. But really, it's simple. Girl said she was pregnant from a BJ. Girl had a positive HCG test, never proved she was pregnant or that the bachelor was the father. Girl loses case because she doctored evidence and lied. And there was no proof of anything to prove these claims that she filed in court. That's pretty much what it is. And she's just a liar and can't just accept the truth because she doesn't like that she's been called out and everyone publicly knows that she is not to be trusted. This is so because the action involved in a single paternity establishment claim, which was tried on the court on June 10, 2024. On June 18, 2024, the Superior Court issued a signed written decision dated June 17, 2024, which fully resolved that claim. The under advisement ruling contained a finality certification as follows. And it says, it is therefore ordered pursuant to Rule 78B, Arizona Rules of Family Law Procedure, that this is a final judgment and it shall be entered by the clerk. The time for appeal begins on entry of this judgment by the clerk. Emphasis added. On July 12, 2024, Laura timely filed a pleading entitled Motion to Vacate Judgment, Motion for a New Trial, Motion to Alter and Amend Judgment. This motion sought relief pursuant to Family Law Rules 83A and 85. According to the post-trial motion, automatically extended Laura's time to appeal from the June 18th post-trial decision, which was certified as a final and appealable, until the entry by the Superior Court clerk of the signed written order disposing of the last such remaining motion, Arizona Rules of Civil Appellate Procedure 9C or 9E1. Although the fee judgment entered in this matter on August 19, 2024 does not contain finality certification, and while it does not expressly mention Laura's post-trial motion, that filing nevertheless fully and finally resolves all issues, leaving nothing further for the trial court to decide. Great. I don't think you need to explain this to the appellate courts because I think they know how it works. When your case is over, you can appeal. I think he's worried about them thinking that it wasn't filed in a timely manner, going by the original date that she put in the order saying you lose. And he's filing it in a timely manner of when he got the rejection for a vacate of judge and a new trial. So I think that's what he's trying to explain here, so they don't just kick it for it not being done in the amount of days it needs to be from the initial thing that Judge Mata put out, the final ruling, where she ruled on everything and we learned what Judge Mata thought about everything. Therefore, the fee judgment constitutes a signed written order disposing of the last such remaining motion. This means the fee judgment is appealable pursuant to Arizona Rules of Civil Appellate Procedure 9E1. Because the rule only requires the entry of a signed written order, which the fee judgment clearly is, not an order certifying the matter as final per Family Law Procedure 778C as the June 18th decision was. Again, because the procedural history of this matter is confusingly complicated, some additional information is helpful to understand why the fee judgment necessarily resolved Laura's post-trial motion, even though it does not specifically mention it. In addition to her post-trial motion seeking relief under Rules 83A and 85 on July 8, 2024, Laura also filed a notice of change of judge for cause. The filing of that motion prevented the named trial judge, Julie Mata, from ruling on Laura's other pending motions. See Arizona Rules Family Law Procedure 6.1D3, explaining after notice of change of judge is filed, the named judge should proceed no further in actions except to make such temporary orders as are necessary to prevent immediate and irreparable harm from occurring before the request is decided. Which we know she did that. Then she withdrew that ruling. So she says on July 18th, 2024, while the notice of change of judge remained pending, the notice judge, Julie Mata, issued a one-line minute entry order purporting to deny all of Laura's post-trial motions. Judge Mata issued this decision, despite the fact that she was prohibited from doing so by Family Law Rule 6.1D3. Several days later, on July 23rd, 2024, Judge Mata admitted this error, claiming she was unaware of the notice of change of judge at the time she denied Laura's post-trial motion. Yeah, because it went to a different thing. It went to Judge Fisk's docket, not Judge Mata's docket. And I don't know if you have to, when you're trying to do that, if you have to file a notice with, the head judge, and then also give notice to the judge that was sitting on your case. But somehow, because it wasn't on Mata's docket and the filings didn't go to her, she didn't know about it. And as soon as she found out about it, she retracted it. And so it says, it has been brought to the court's attention that notice of change of judge for cause, memorandum, and affidavit in support filed on July 8, 2024 before the presiding family court judge, Honorable Rhonda Fisk. This court prematurely ruled on petitioner's motion to vacate judgment, motion for new trial, alternatively motion to alter or amend judgment, motion to leave to exceed page limits filed July 12, 2024, unaware the notice that would suspend the court's authority. Let the record reflect on the ruling on the motion is hereby withdrawn pending further action from the presiding family court judge. So she withdrew it, as she should. She fixed her mistake. Like, the appellate courts aren't going to be like, oh, well, she shouldn't have done this in the first place. Like, so your whole trial needs to be redone. No, he's just tattletelling for no reason. After Judge Mata withdrew her prior order denying Laura's post-trial motions on August 14, 2024, the presiding family court judge issued an order denying Laura's notice of change of judge. The order, authorized by Judge Mata to rule on all remaining pending matters, included Laura's post-trial motion. 5 days later, on August 19, 2024, the court issued the fee judgment awarding nearly $150,000 in attorney's fees and cost to respondent appellee Clayton Echard. While the fee judgment does not expressly mention any arguments raised in Laura's post-trial motion, the fee judgment nevertheless implicitly and summarily denied Laura's request for relief, i.e. Laura's post-trial motion raised numerous arguments which would necessarily preclude an award of fees to Mr. Echard if those arguments were sustained. Accordingly, by awarding fees to respondent, the trial judge necessarily denied Laura's post-trial motion for relief. Therefore, pursuant to Arizona Rules of Civil Appellate Procedure 9E1 or 9C1, the fee judgment is appealable because it constitutes a signed written order resolving Laura's post-trial motion which sought relief from the prior certified final order. In the alternative, even assuming the fee judgment was not otherwise appealable, the case fits squarely within the Arizona Supreme Court's rules explained by a case from 1981 allowing premature appeal brought before entry of final judgment and explaining to avoid the judicial gymnastics and yet arrive at the same result. We hold that a premature appeal from a minute entry order in which no appealee was prejudiced and in which a subsequent final judgment was entered over which jurisdiction may be exercised needed not be dismissed. Okay, that's a lot of mumbo jumbo. To be sure, the Court of Appeals also recognizes the other court case rule is limited in scope. More recently, our Supreme Court reaffirmed Barassi, explaining that the appellate court should dismiss a case for lack of jurisdiction, while a time-extending motion was still pending in the trial court. Craig v. Craig. Appellate Court from 2010. And then some other ones, and it's from 2006. Here, no time extending motion remained pending. Thus, despite the narrow scope of Barassi, the law remains clear. Barassi allows a notice of appeal to be filed after the Superior Court has made its final decision, but before it has entered a formal judgment. If no decision of the court could change and the only remaining task merely ministerial. And then he goes to cite another case. And the last page, from my understanding, is a signature page. That's why we don't have the 5th page. But basically that was saying, I can do this now, even if everything isn't final, because she's issued her final judgment. He's saying, I have the right to file this. That's all his notice was saying. And it was long. And apparently notices of appeals are not all that long. You say, I am going to appeal. The end. So then, on September 9th, a few days later, he files this amended notice of appeal. Because apparently he didn't say a bunch of hoopla in the last one. Like there should be no amendment to the notice of appeal, because it should just be, I am going to appeal. Here's my notice that we are appealing this case. Goodbye. But he says, pursuant to Arizona Rules of Civil Procedure, Appellate Procedure 8A and 9A, Petitioner Laura Owens, Laura or Petitioner, gives notice that she hereby amends the notice of appeal previously filed in the case on September 5th, 2024. To be clear, this amendment is made solely to address an order issued after the original notice was filed, as explained in the original notice of appeal. On August 19, 2024, the trial court issued judgment in the final order that implicitly denied an entire time extending motion that sought relief under Family Law Rules 83 and 85. Although the August 19, 2024 fee judgment order did not expressly deny or even mention the pending Rule 83 and 85 motion, the original notice of appeal explained the order was nevertheless appealable. The August 19th fee judgment is appealable pursuant to Arizona Rules of Civil Appellate Procedure 9C1 because that rule only requires the entry of a signed written order, which the fee judgment clearly is, not an order certifying in the matter as a final per Family Law Rule 78C, as the June 18th decision was. Notice of appeal at 225-28. And I think that's because, I guess she could issue it, and I don't know if she ever did. I know she reissued that order eventually that she withdrew. She reissued that, but I don't know if there's really finality when it comes to family law cases, because it could be ongoing. Even if that particular issue is handled, I guess they could close that case out and issue finality on that. But I don't know if they just kind of leave it open because the kids are going to be children for 18 years. So that's something interesting. I'm not a lawyer, so I don't know, but maybe that's part of the reason why there's not like, this is final. But she said in her judgment that she issued, consider this final. Consider it settled. This is done, over. You can start your appeal. Leave me the heck alone. He goes on to say, in other words, the original notice asserted the August 19, 2024 fee judgment should be treated as signed written order that resolved by denying a pending motion to alter and amend filed by Laura on July 12, 2024. The July 12th motion sought relief from minute entry ruling filed June 18, 2024, which was certified as final and appealable pursuant to Family Law Rule 78B. This meant Laura's time to appeal the June 18th ruling was extended until the entry of a signed final order denying the July 12th motion. See Arizona Rules of Civil Appellate Procedure 9E1C. Thus, the original notice of appeal identified the August 19, 2024 fee judgment as the primary order being appealed because it granted relief that was possible if the July 12th motion was denied. Despite this, earlier today, on September 9, 2024, the Superior Court issued a new one-line minute entry order purporting to deny the July 12, 2024 motion to alter and amend. The September 9th minute entry order is unsigned and does not contain a finality certification pursuant to Family Law Procedure 78B. So I guess it didn't have this finality thing signed on it or something. I don't know why that wouldn't have been there. Maybe that's a filing error. Nevertheless, for the same reasons explained in the original notice of appeals, the unsigned September 9, 2024 minute order is final and appealable pursuant to the rule explained by Barassi v. Matson. And he mentioned that in the original one. So he's saying, just even though it's not signed, I can still appeal it. Great. Why are you explaining this to people who know about that? To eliminate any possible confusion or doubt as to which orders or judgments are subject to the appeal and which are not, Laura gives notice that her original notice of appeal is hereby amended as follows. In addition to any or all orders identified in the original notice, Laura also appeals to the Arizona Court of Appeals from Superior Court September 9, 2024, order denying her July 12, 2024 motion to alter or amend. See in remarriage of Thorne, Appellate Court 2014, explaining this Court of Appeals only acquires jurisdiction over those matters identified in a timely filed notice of appeal, but explaining appeal notices may be amended as needed to address new issues. Amended notices of appeal have been recognized and at times implicitly encouraged, emphasis added, explaining grounds for amending notice, citing Craig v. Craig and some more stuff. Here, the original notice of appeal was timely because it was filed on September 5th, 2024, which is less than 30 days from the date the fee judgment was entered on August 19, 2024. The amended notice of appeal is also timely because it seeks review of the minute entry order filed earlier today. See Arizona Rules of Civil Appellate Procedure 9E3, explaining a party intended to appeal one or more of the orders disposing of one or more of the motions listed in Rule 9E1 must file a notice of appeal or an amended notice of appeal under Rule 8 within the time prescribed by Rule 9. Emphasis added, dated September 9, 2024, signed by David Gingras. So there is their notice of appeal and all that. So that could take a while. I mean, he hasn't filed his appeal yet, but once we have that, we will bring it to you, of course. And then it may take a while for the appellate courts to get to it, or they may just be like, yeah, we're not even hearing this to oral arguments. Denied. Sit down. Be quiet. Go on about your life. We are making this stand. But, it really begs the question with Clayton's order against harassment. Like, I wonder, he could probably do something about her continuing to put out like Medium articles and things like that. Basically stating what she thinks has happened because the judge has ruled that that is not truthful. So she's still out there spinning untruthful things by saying that he did all this stuff to her. Like, so could she be breaking or violating her order against harassment that she continues to keep doing to him? Because we know she likes to report violations all the time, even when they're not real violations. But I don't know that Clayton cares enough. Like, he's got the judge that ruled, he's got the judgment, he's had everybody see, like, he's spoken his truth, and is just like, she's just going to keep spinning in her own little world because that's what she does. She does not know how to stop. But somebody needs to make her stop. And I'm hoping that's where the criminal charges come in, to tell her, stop. because now you're getting a slap on a wrist because she's probably not going to jail. But if you do this again, it's going to be worse than like probation or paying a fine. Stop what you're doing and move on. You have lost. Go on about your life. Suck it up, Buttercup. That is it for me today, and I will see you in the next one. We are going to start breaking down the other lawsuits, the Uber and the Lone Star Construction lawsuits coming this week. Stay tuned. Hit subscribe, like, and I will see you later.